Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the extra mile when you're studying for your bar exam. And now your hosts, Jackson Mummy and Megan Saya from Celebration Bar Review.
Hey everybody, welcome. It is Wednesday, May 4th. We have entered the month of May. Holy cow, hard to believe. Hi Megan, how are you?
Hi, doing great. How are you?
I'm excited to be in the month of May. It feels like maybe we've turned the corner and we're starting to head towards the July exams, but we still have some exams to wrap up results from February, right?
Yeah, California is just a couple days away. Pretty exciting.
It is exciting, and we're going to talk about that a bit. We're going to update everybody on the results we've gotten in the last week. There have been a number of smaller jurisdictions that have reported results. We're also going to answer student questions. We've gotten a lot this week, so we're going to try and get through those. And then we are planning to talk about jury trial rules for the multistate, right?
Yes. Yeah. I thought that might be a little bit of a lighter, fun subject as opposed to some of the drier things that unfortunately you have to know for the bar. But jury selection and trials is a little more interesting to a lot of people, I think. So
it is. And federal civil procedure has continued to be a really tough subject for people on the MBE. So I think it really will help. So stick around for that. We've got a lot on the agenda. So I'm just going to turn it over to you, Megan, and let's go ahead and.
All right, let's start with results and talk about updates since last week. So they continue to roll in and are really pretty consistent with what we've already been seeing for the February exam. Our one outlier, as we've seen, that the outliers are really anybody over 50%, just seems like a bit something to be celebrated, which is kind of crazy. But Colorado had a 51% pass rate. The rest are really where we would expect. We had Connecticut with 44%, Massachusetts with 44%, Ohio with 47%, DC with 42%, and then Alabama, rough go of it in Alabama, they only had a 35% overall pass rate for this February.
Yeah, this is pretty startling in the sense that we know that the numbers are headed down across the country. I've talked to a fair number of people in the last couple of weeks who are inquiring about taking our course in the exam. And when I tell them that the statistics are not weighed in their favor, they seem shocked. They shouldn't be. These numbers have been going this direction for a while. And we also know that obviously a February test has got a lower pass rate than a July test because you do have more repeat takers, but the repeat numbers are just horrific, really, almost everywhere. And so if you're a repeat bar taker, we know that's something that you've got to deal with. And that's why it's so important to get all of the tools and help that you can get. This is just not a test as it's going right now that most people are going to be able to maneuver as repeat takers, just sliding by or doing what they always did. It's pretty clear from these numbers.
Yeah, definitely. If you look at the repeat pass rates that have been released, it's really common to see them in the 20 and 30 percentage points. That's pretty bleak, right? When you're looking at 20 something percent of repeaters passing. And some of these jurisdictions, that's a handful of people. Oh, it's really just a dozen or so. It's pretty bad. I don't want people to be discouraged or pessimistic or feel like it's impossible. But I think what I do want to stress to people is that you're going to have to be all the way in. I just think if you're for anyone, but certainly for repeaters, there's really not going to be a clear path forward to passing your exam unless you are 100% on board, committed to studying, to taking the time and doing that. And Jackson, I know we'll get into it a little bit later, but certainly I know we're talking to some students who are feeling a little bit, I don't know, I'm not really feeling it right now. Should they sit for the July exam if they're wishy-washy about the whole thing right now?
Yeah, I think this is a great question, but my view is if you're not all in, don't take the exam. This is not a test that you can just back into anymore. It's not a test that you can be half-hearted. And sometimes it's for the best of reasons, right? You've got family issues, you've got health issues, you've got work issues. There are things that can come into play here that really should override the bar exam. I think we're in the environment in which you need to be, what was that character? Remember in the movies, the one that ran through walls all the time? And I think it was like X-Men. I don't know. Anyway.
All I could think is the Kool-Aid Man.
Well, there's that. Yeah. Okay, we'll go with that. But that's creepy. I was
I'm
in it.
I'm a 90s kid.
Back in the 60s, there was a Kool-Aid commercial where he did that, and I was in those commercials. But anyway, that's so weird. It was the Hulk. Okay, fine, I'm going to go with that. But if you don't have that kind of mentality of, I'm just going to burst through every barrier that's in my way, I think it's really hard. And so when I'm getting results back from those students we have that were not successful, and I want to say we are outperforming the state averages for repeat takers everywhere, and it's self-reported, but it's pretty clear that we're doing that. But when we have students that don't pass, and I talk about what they have to do going forward, one of the things I say to them is, look, there's no dishonor in sitting out the exam and giving yourself enough time and space and the resources to be successful. There's no value to just going and getting the snot kicked out of you time after time on the bar exam. And so I think you got to be all in. That's my take. Where are you on that?
Yeah, I just think that you want to be realistic about where you are. And so whatever that looks like, there's no judgment from our side about, we do everything possible to make it so that you can defer if you need to. We're not going to penalize you for doing that. We recognize that everyone, and particularly the students who we work with, have really difficult situations oftentimes that have contributed to the reason why they're coming back over and over again to the bar exam. And so we certainly never want anybody to feel stress or shame or guilt or any negative emotion about needing to defer. I just want people to be realistic about if it's possible right now for them to give it their 100%. And if it's not, then you might want to at least consider if you need to defer.
At this point in early May, no one feels ready for the exam. So
Right.
That's not the reason to defer. You've got 90 days to get ready, and you can get ready using this course very effectively. So that's not the reason to back out. But if you are feeling like, oh, I just can't get up in the morning and study, and you haven't studied in weeks, and you don't see yourself putting 20 hours in your schedule for the next 7 days, let's be realistic. That's not going to get you there. So I see folks on this call today that I know are working hard, and I know that some of them are thinking, well, maybe I should defer. Don't defer. Don't defer. If you're working, don't defer. But if you're not doing anything and you're just staring at it, then talk to us. Let us know, because I think it makes sense to postpone. So that's where I think we come out there.
Okay, great. So we definitely, I want to note again for California students, anyone who took the February exam, that the results will be released this Friday at 6 p.m. Pacific time. It's very exciting. Please let us know how you did, pass or fail. We want to be here to celebrate with you, or we want to be here to help you if you're going to have to retake. Jackson, we were talking about this. I don't anticipate, when we're seeing these low numbers across the board, I'm not anticipating any particularly low number for California. It's always low in California. I am anticipating that it will remain low, but I am not expecting some giant drop off or anything. How about you?
Yeah, I'm going to follow your lead here. You're the expert on the Cal Bar. I think that it will not be a good number, but I don't think it will be a remarkably lower number than it's been. I think the Cal Bar is trying hard to bring more people in. They've made some changes that I think are good. They're being more transparent. The exam is still a killer of an exam, and we know that. If you are successful, feel really good about it. If you're not successful, dust yourself off. There will be enough time for you to study and prepare for the July exam. We will get you immediately back into the course, ready to go. I'll get videos prepared for you as soon as I get your score sheets. We'll do everything we can to assist you. But let's be candid about this. We're not going to see a 50% plus pass rate in California. That's just not going to happen.
Definitely not. Yeah. I'm not expecting a crazy low number relative to California's normal score. I'm also not expecting a crazy high number relative to California's normal pass rate. So yeah, that's exciting. We'll talk next week about what California looked like. And the final thing I want to mention in this realm is that DC announced a cap on their seating again. This is something they've been doing. Reminder that DC is a UBE jurisdiction, and so you don't have to physically sit there in order to be admitted to the DC bar. But for anyone who's planning on it, they are capping it at 1,100 people. And what they're doing is they're having registration first only for first-time takers who graduated from DC law school, so American, Georgetown, etc. So if that's not you, then you're going to have to wait to register until it gets opened up on May 18th to all registrants, and then it's going to close. That's first come, first serve at that point, and it'll close when it's full. So we'll see how many people register. They're not going to release that. They'll see how many people register during the initial wave, and then whatever seats they have left over, they will open up to the general public. And as soon as those are gone, they're gone. So I do know a lot of people are making plans already, saying, you know what, I'm just going to go ahead and take it in New York, or so wherever it can make sense. If for you would be traveling to DC, let's say, in order to take it, maybe don't travel there, or at least hold those plans with an open hand so that you can modify without panicking if necessary.
Yeah, it's interesting, these limits. I'm not sure that we'll see limits elsewhere, since we're all just basically assuming that COVID has gone away. I don't know what to think about that, but it doesn't matter. You don't have to sit in DC to apply in DC. And of course, the DC passing score is the same as New York, New Jersey, a bunch of states. It's at 266. So unless you're in the DC metro area and it's just more convenient for you to take the test there, I wouldn't put yourself through the stress of the rope drop, we call it at Disney, on May 18th. But you can sit a lot of places and be just fine. So think about places like New Mexico and Alabama that are smaller and probably less expensive to apply for.
Great. All right.
Let me just add that in the community group, we're posting what we're calling Monday poll questions. This Monday, we asked you, what's your worst study habit, which I think is really interesting to see what people said about that. I encourage you to join in and get into that conversation. It's really there to give you some sense of support and accountability, but also just knowing you're not the only one out there dealing with those things.
And our last announcement, I know that this always comes up whenever there is a big change in constitutional law, particularly. There's always a lot of stress for bar takers, feeling, oh gosh, what do I do? I've been studying one thing and now things are changing or not changing. So we did want to acknowledge the news that broke that there was the draft opinion leaked that would be overruling Roe and Casey. And so we're not going to obviously talk about the political or social implications of that, but we do want to talk about the implications for the bar exam and for your studies. So Jackson, if you want to speak on that.
There's a couple of things to keep in mind here. One is that your exams in July were written 3 to 6 months ago. So they won't reflect anything that would happen. We would expect this draft opinion would become the opinion of the court sometime in the next month or two. It will not show up on the bar exam. You don't need to worry about it. That's number one. But number two is the bar examiners are pretty savvy about watching what's on the docket for the court, particularly in con law and crim law. And when they see those things out there like Roe that have the potential to be overturned, they steer far away from those subjects in the essays. I don't expect any con law essay that even remotely touches on privacy rights. But within the MBE, they also pare down. The NCBE will stay far away from this topic, and you will get only the most fundamental privacy kinds of questions, because that is on the outline. They have to do some, but they are not going to be anything around Roe or Casey or Bergerfell or anything that we would think of Griswold. We're just not going to get that. So don't worry about it. Bottom line is that from the standpoint of the bar exam, this is, I mean, I hate to put it this way, but it's a nothing burger. It doesn't mean anything to the bar exam. It has a lot of implications in the bigger world, but for us, absolutely nothing. Now, when we start talking about February of 2023, it could be different, but we'll see at that point.
Yeah, like Jackson said, we expect this opinion is probably going to come out in June, and we don't know yet what it's going to look like, if this is going to be the prevailing opinion or if there'll be edits. But please rest assured that then for July, it's not going to impact you at all, certainly coming out right a few weeks before the exam. For February, we will get any changes to constitutional law into the outlines. And so you will have the most updated information to study. So regardless of whether it makes it onto the test or not, let's say in February, you will be able to study it's very small what you need to know for the purposes of the bar, but that those changes will be reflected in the outline as soon as they are official. And so we don't want you to stress if you're a later exam taker, there's nothing that is going to deeply impact you. Also, please know that sometimes it's hard, right? The punditry, there's a lot of discussion about what this means for unenumerated rights in general and the right to privacy in general. that's not going to be testable on the bar, because as long as let's say Obergefell is still the law of the land, then that's it. They're not going to test you on the potential for it to be overturned following this case. So if that makes sense, I don't want people stressing out. I know it can be hard whenever there's a big piece of legal news. It's very hard to understand that it doesn't really impact the bar as much, the bar exam, as you feel like it would, just because it's all over the culture at the moment. All right, thanks. With that, let's move on to student questions. We got a lot of great questions this week. And all right, let's start with some questions about changing. I love this. We had a student who has been spending some time in Florida and was wondering, can I change my UBE test to a Florida bar review? What are your thoughts about changing jurisdictions? And am I kind of starting totally over with my studies? Is it not worth it? Or is it okay to make that switch from a UBE jurisdiction to a state-specific jurisdiction at this point?
Yeah, it's a tough question. Florida is a tougher exam than the UBE, but the weather's better here generally. I mean, there's a lot of UBE states where it's not so good. I think this person was thinking about Massachusetts versus Florida, so I get that, having lived in both places. If you're going to make the switch, you need to do it now. At this 90-day point to the exam, you need all the time that's there. The multi-state is the same between Florida and the UBE, but everything else is different. Florida's day one is state specific for the most part, and you're going to need to learn and study that. So I think it's a question of where do you want to live and where do you want to work. Florida does not have reciprocity, which means your UBE score will not do you any good, even if you're admitted somewhere else. You still have to take the Florida exam to pass or to be a member of the Florida bar. So it's one of those states like California that's very restrictive. And if you want to be in Florida, you got to take the Florida exam. Now, is it easier than the UB? Not at all. Much tougher. So I think that's a consideration. The other thing is that there are early registrations and late registration deadlines. You can always register for Florida late. You're just going to pay a bigger and bigger fee. They're glad to take your money almost any time. So.
It says, Jackson, in your video, you mentioned I should be studying 3 hours a day, but I had a medical delay. So I assume that time has now increased, which is fine. So starting Monday, would you suggest I do 4 or 5 hours per day or more than that?
Yeah, I'm really reluctant to ask people to study more than 4 or 5 hours a day at this stage. I don't think it's necessary. If you're just starting out, and I imagine the student is probably a little bit further along, I still believe that about 20 hours a week, maybe 25, is a reasonable number of hours to spend. Obviously, the closer we get to the exam, you still have to compress those hours in. You got to get them done. So if we ask this question a week from now, it's a little bit more. 2 weeks from now, it's a little bit more, and so on. But I would be cautious, I think, Megan, to what you're feeling, but I would be cautious about trying to commit yourself to 5 hours a day at this point. I think that's a lot.
Yeah, we just don't want people to burn out. So again, it goes back to what we were talking about earlier with, you have to be honest with yourself about what you actually have time for. So don't look at your schedule and go, gosh, okay, if I don't do anything outside of my house for the next several months, then I can do X number of hours. Or if I don't take care of myself, if I don't cook any of my own meals, or I don't go to the gym, or I don't see friends, we don't want you to do that. That's not healthy. And it's ultimately not going to help you pass the exam either. So be realistic about what can fit into your schedule. Look at how much you have left to do and see if you are able to be consistent. I think that's probably the key right now, is don't have a week where you did 5 hours the whole week and then try to make it up in the next week. Be consistent, slow and steady wins the race for sure on the bar exam. So this is actually our last question as the study strategies. So we had someone, I think it was probably the same person, who said they felt like the lectures were too long and they were sort of, can I just skip the lectures? I don't think I want to listen to them. I already know the law and I don't need to do this. I'd rather spend my time outlining and practicing. And then I think they talked to you and you said, go through the course. We know what we're doing. Go through the course as is. But this person wanted to see if this approach is okay. They said they watched the lecture first and then they read the outline and felt like they understood the information better and didn't have to stop the lecture often throughout it. And so they were able to do it much quicker, and asking if that is an okay way to go through the course.
Yeah, Yeah, it's so the first part of this is do all the steps for sure. We want you to do the reading, even if it's just skimming. And certainly if you're a photo reader, we absolutely want you to do it. We want you to also go through the lectures because that's how you activate what you've read. And we want you to do the question practice. Now, the secondary question is, can you switch the order of those three things? And the answer is, yeah, you could listen to the lecture first. But if you're a photo reader, I don't want you to do that. I need you to photo read first. Now, if you're a traditional word for word reader, I can certainly understand why you would feel more comfortable in some cases doing the lecture and then doing the reading. The supposition behind this, however, is that the reading is going to actually help you and you're going to understand it and gain clarity. That's a bit of a false flag. It's not likely that will happen. It's not designed to do that. We don't want you to read word for word and get all of this great comprehension. We really want you to learn through the combination of the three parts, the reading, the lecture, and the question practice. So for this student, what I said was, okay, if it makes you feel better and you're not a photo reader, go ahead and do the lectures first. But in general, I would say follow it the way we've laid it out. That's what we know works the best. And we really encourage that. And if you're a photo reader, you absolutely have to photo read first.
Wonderful. All right, now we can turn to our practice MBE questions. I love this so much. So we're gonna dive into those. And I really hope that people pay attention when we get to the practice questions and guess, like give your best guess. So pay attention when Jackson's going through the mind map and maybe even take notes on things from the mind map and then try your hand at practicing the questions themselves.
I've been doing a continuing series of the study questions that keep you awake at night, and there's no doubt about those. There's plenty that work that way. And today we're going to talk about something that I think will be interesting to many of you, and that is, what are the rules for jury trials? It's a fairly important topic. It's one of the primary topics within federal civil procedure, and so we wanted to do a more extensive mind map and then try some practice questions. So I want to start as usual by just giving you a brief overview. This is what the mind map looks like. If you're in BarMaps, you've already got this accessible to you. We will place this mind map as a downloadable PDF with links in your online course access. And if you're not in our course, you can also buy this series of subjects that we do, and now I think we're up to 10 or 11 subjects. We'll put a link in the show notes to explain that to you. But jury trials is the third topic within federal civil procedure, and you may not be able to read it because it's so small, but there are really three subtopics. The first one on the right is the right to a jury trial. Then we've got requests and objections to jury instructions, which we're not going to talk about today. And then we've got selection and composition of the juries. So that's where we are subject matter wise, and we will look at those in more detail. So what I do want to do is break this mind map down for you now in a little more detail so that it's a little more readable for you. The first subject, as I said, is the right to a jury trial. And the first thing you have to understand about this substantively is that the right to a jury comes from the Seventh Amendment. And that's critical because the Seventh Amendment is the demarcation point between equitable and legal rights. And that becomes really important because when we talk about the availability of a jury trial, sometimes we think everybody gets a jury. That's not actually true. If you have, in terms of availability, how do you get a jury trial? It starts with suits at common law, but if you're making a request for an equitable claim, that is not eligible for a jury. And that gets really tricky because then the timing of how that happens can affect whether you get a jury trial or not. And you'll see that's good material for the bar examiners to test. Jury trials can be applied to statutory and administrative proceedings. Important to know that. And they can also be available at a judge's discretion, which is nice. So if you see an answer that says judge's discretion, that's usually the right answer. So keep that in mind as well. Now, when I talk about those legal and equitable claims, we've got to break that down. And one of the things you want to understand is that in order to preserve the right to a jury trial, the legal claim has to be tried first. That's a really important principle because when you'll see in these MBE questions, oftentimes you're presented with a legal and an equitable claim. What you're looking for is how do you get the legal claim tried first if it's asking about a jury trial? And then there's a series of permutations, like what happens if the plaintiff joins legal and equitable claims together? What do you do there? You start with the legal claim. What if the defendant raises a legal counterclaim to an equitable claim? Do you get a jury trial there? Interesting question. and then if a legal claim is raised in an equitable proceeding. So you can see there's lots of different possibilities. Now, I'm not going to go into detail on any of those today, but it's something you want to be clear on because these are the kinds of permutations, I think, that affect people. Megan, is that a fair way to explain it?
Yeah, that's great.
All right, let's keep going here. The effect of state law is a subject in this area, but not one that the examiners test very often. So we're going to skip it for today, but it's in your outlines. The next big piece of the right to a jury trial is the demand, and when you make the demand and what its effect is, and can you waive it? And as you see, when we talk about the demand for a jury trial, the timing is really important. If you don't remember anything else out of this discussion today, remember 14 days after service of the last pleading. The examiners love to test this, don't they, Megan?
Yes, definitely. So yeah, drill that into your head that the demand can be made anytime before 14 days after the service of the last pleading.
And it can be made in the pleadings or by a separate motion. But for some reason, I know you went through lots of questions. It just comes up over and over again, doesn't it?
Yeah, it does.
All right. So in terms of the effect of a demand for a jury trial, one of the rules is that a demand can't be withdrawn without the consent of all parties. That's a pretty important rule. Again, something to lock into. And then finally, the demand in a state court will survive removal to federal court. And that's really the most important effect of state law, I think, is that if you demand a jury trial in a state court trial, and then your case is removed to federal court, you're still going to have a jury trial. And then finally, what about waivers? The parties can agree to waive the right, but all the parties have to agree to it. So those are the primary rules for demands for a jury trial. And a lot of questions in civil procedure come right out of this section. Now, there is, as I said, another piece of this outline, which is requests for and objections to jury instructions. We're not going to go into that today, but it's an area in your outline. And then we get to what we call selection and composition of juries. And this is an area where I think you're going to see some questions as well. And what you want to be aware of here is that you're going to have to be aware of the number of jurors. I'll tell you that's 6 to 12 jurors, and that's the number that we can have. But the selection of jurors is more important in terms of questions. And really what we're looking at here is that you have a cross-section of the community. It's supposed to be without systematic exclusion. Those are the codified and Supreme Court decisions around jury selection. But as many, there are also what are called challenges for cause. You should know that those are unlimited, and they are based on a relationship between the potential juror, a relationship to the litigant, or otherwise biased. And otherwise biased is a big, broad description, but if there's a bias, you can challenge for cause, and that's what you're looking for. And then, and I think this is surprising to people, in the federal system, you're only granted 3 peremptory challenges. These are the optional challenges, if you will, based on occupational or social attitudes that might be unfavorable to your case. So you don't have to give a reason, it's just a peremptory challenge. I think where people get surprised is they think there's, and I think TV has done this, doesn't it, Megan? You can have an unlimited number of peremptory challenges. That's not true.
Yeah, I read, I feel like John Grisham novels, right, would get into the minutia of this kind of, oh, who are we going to use the preemptory challenges on? Because we only have a few.
Or bull. So there you go. So that's what we've got. You should know those 2 rules because, again, they're tested on the exam. All right, so that's what's in our mind map. Now, as always, what we want to do is give you a couple of questions and have you work through them. And as Megan said, we'd like you to jump in here. We've got many of you on the call today, and put in your answer. Tell us in the chat box what you think. Let me read question number 1. It's a short question. A patent holder brought a patent infringement action in federal court against a licensee of the patent. The patent holder believed that a jury would be more sympathetic to his claims than a judge and asked his lawyer to obtain a jury trial. Here's the call to the question. What should the lawyer do to secure the patent holders to a jury trial? So they're asking a pretty straightforward question, aren't they? What do you have to do to get the right to a jury trial? Now, before you look at the answer choices, think to yourself, what do you have to do to get a jury trial? It should be pretty clear, right? Hopefully, we're not going to get distracted by the answer choices, but let's go ahead and look at them. So what should the lawyer do to secure the patent holders to a jury trial? Answer A says file and serve a complaint that includes a jury trial demand. B says file and serve a jury trial demand at the close of discovery. C, file and serve a jury trial demand within 30 days after the close of pleadings. And D, make a jury trial demand at the initial pretrial conference. I'd like you to make your choice, A, B, C, or D. And while you're doing that, Megan, do you have any thoughts that you want to add as you're looking at these answer choices?
I think it's don't overcomplicate it, right? Like if you were here 2 minutes ago, then you know everything you need to know to answer this question. So don't overthink it. Don't talk yourself out of answers. When you first heard that, what should the lawyer do to secure the patent holder's right to a jury trial? You should have gotten some answer in your head and find that answer here in front of us.
We got any answers in the chat box?
Yeah, lots of A's.
Oh, okay. If you said A, you're correct. And to Megan's reasoning, it is the straightforward, simple answer. Federal Rule 38B1 provides specifically that a jury trial demand can be included in a pleading. That's simple, it's straightforward. So if it's properly filed and served, the complaint serves that right. So that's the obvious answer. But I want to look at B, C, and D because they help us understand the rule a little more directly. But congratulations if you chose A. If you chose answer B, to file and serve a jury trial demand at the close of discovery, remember what we said, the demand has to be served no later than how many days?
14.
14 days after service of the last pleading. The close of discovery could be a lot later than 14 days. So that's why that's the wrong answer. And if you started to think, but it's only after the close of discovery, nope, you overthought it. 14 days is the number you're looking for. Answer choice C basically takes the same approach. File and serve a jury trial demand within 30 days after the close of pleadings. Nope, our number is 14, right? Say it all together, 14 days. So that won't work either. And then answer choice D says make a jury trial demand at the initial pretrial conference. Again, we're dealing with 14 days. And typically a pretrial conference could be weeks after the pleadings have closed. If you chose B, C, or D, it's because you overthought it, don't you think?
Yeah. Sometimes I think we can talk ourselves out of the right answer because it seems too simple, but don't do that. That's what selective intuition is. It's like you knew that in your gut. You're like, all the lawyer has to do is ask for the jury trial, and it has to be somewhere in that 14-day period before the last pleading. And that's it. It's just that simple. So good job, everybody.
Yeah. So if it's in my initial pleading, by definition, I'm within 14 days. Okay.
Yeah.
All right, question 1 in the books. Let's go to question 2. Oh my goodness, look at this. Which is true regarding the right to a jury trial? What do you think about these kinds of questions, Megan?
I have to say, I love them because you can't get wrapped around the axle with all these extraneous facts. Even in that last one, they give you all this information about the patent holder and they're suing for the patent. We don't care about any of that. It doesn't have the question they're asking doesn't have anything to do with those facts. They're just there to mess you up. So I actually really love questions like this, where it's just a very straightforward, you can't get lost. Let's dive in. And if you see something that's true, that's it. You have your right answer. It doesn't matter if you're unsure about other answers. If you know that one of those answer choices is true, then that's it. That's your answer.
Which is true regarding the right to a jury trial? A, an action in contract may be tried before a jury regardless of the type of remedy sought. B, a declaratory judgment is an equitable remedy not giving rise to a right to a jury trial regardless of the underlying claim. C, a jury trial must be demanded in the pleadings. And D, the demand for a jury trial can be withdrawn only with the consent of all the parties. So now we're going to see if people were paying attention when I went through the mind map, right? Okay, A, B, C, or D, take your choice. Put it in there. I think to Megan's point, this is in some ways the easiest kind of question because all you're doing, 3 of these statements are wrong. Just look for the right one. Don't make yourself crazy trying to analyze all of them. Just look first. What's the right one? What's the one that hits you and says, that's got to be the right thing? And it's often the simplest. It's the one that is the most direct because all the other stuff, the more words they put in my experience, the more possibilities that the answer is going to be wrong. So there you go. We given them enough hints?
Yeah, we've got a lot of D's.
Okay, D is in dog, right?
Yeah.
All right, should we take a look here?
Yep.
All right, let's go. Answer choice A said an action in contract may be tried before a jury regardless of the type of remedy sought. That is the incorrect answer. Remember we talked about you have to characterize a claim as being legal or equitable. In order to do that, the court looks at what kind of remedy you're looking for. So a contract action, which seeks specific performance, that's an equitable claim, not a legal claim or equitable remedy, and therefore that can't be tried to a jury. So again, if you start trying to overanalyze this, you're going to get in trouble, right? It's just it's too much to work through in my. Okay, let's look at answer choice B. It says a declaratory judgment is an equitable remedy not giving rise to a right to a jury trial, regardless of the underlying claim. I think for a lot of people, the idea of a declaratory judgment might be confusing to them, don't you?
Yeah, this is the most complicated answer choice in terms of they use a whole lot of words
Sure
to
do.
say something that's not that complicated, but they make it sound pretty complicated.
Yeah, declaratory judgments are really just judgments by the court without the remedy is not something that exists at common law. So as a result of that, the court has to go then and look at the underlying claim and say, is it legal or equitable to decide if you get a jury trial? That's a lot of work to go through, and it's a lot of steps to unravel. So in my mind, just as a test-taking principle, I would probably drop this answer almost immediately, because if I don't feel really clear on what a declaratory judgment is, it almost certainly can't be the right answer. Okay, so if you answered B, is because you, again, overthought it, in my view. What about answer C? A jury trial must be demanded in the pleadings. We know the answer to that, don't we? When can you file a demand for a jury trial? It could be after all the pleadings have been filed. So it doesn't have to be in the pleadings. Remember, we learned that. So again, overthinking. And that leaves us with answer choice D, which is correct. A demand for jury trial can be withdrawn only with the consent of all the parties. Remember, that was in our mind map. We said you could only withdraw with the consent of all the parties. So again, that's the simplest answer out there, isn't it?
Yeah, it is. And I think to that point, if you're reading these questions through and or the possible answer choices, and you get to answer choice D and you read that and you said, oh, I know that's true, then it doesn't matter if, for instance, B was really confusing to you. It doesn't matter. You're just looking for the one true statement. You found a true statement. You can mark it and move on.
Yep. All right. We're going to get to 3 questions here today. Yay us, Megan. Let's go to question number 3. A wholesaler brought a federal diversity action against a large pharmaceutical company for breach of contract. During jury selection, one potential juror stated that 5 years earlier he had been an employee of the company and still owned several hundred shares of its stock. In response to questioning from the judge, the potential juror stated that he could fairly consider the evidence in the case. The wholesaler's attorney has asked the judge to strike the potential juror for cause. Now our call to the question. Should the judge strike the potential juror for cause? So we're into jury selection and composition, and we're dealing with a strike for cause. So I think this is a good example. We know we're going to get 2 answers that say yes and 2 answers that say no. So before you look at the answer choices, clarify in your own mind, should the judge strike the juror for cause? You should be able to determine yes or no and have a general principle behind that decision before you look at the answer choices. Right, Megan?
Yeah, exactly. So try and figure out if you think yes or no, and then why. Like really simple statement in your head. Maybe it's a word or two of why do you think that's the right outcome?
Yeah, so on your scratch paper, just write down yes, no, here's my reasoning. Do that before you look at the answer choices, because the answer choices tend to confuse people rather than help them. So now we're going to look at the answer choices. All right, remember the call of the question here is, should the judge strike the potential juror for cause? Answer choice A says no, because the potential juror said he could fairly consider the evidence in the case. B says no, because the wholesaler's attorney could use a peremptory challenge to strike the potential juror. So those are our 2 no answers. Now we've got a yes answer for C. Yes, because other potential jurors still remain available for the jury panel. And D, yes, because the potential juror is presumed to be biased because of his relationship to the company. All right, A, B, C, or D. I think this, again, is very straightforward and simple. You should have already identified whether the juror could be struck for cause before you looked at the choices. So now you're just looking at your 2 yes choices or your 2 no choices. Is that a good way to analyze it, Megan?
Yeah. And all these D as in dogs came in flying fast and furious.
We love, oh, you guys are getting to be so smart. All right. Answer choice A said no, because the potential juror said he could fairly consider the evidence in the case. That's incorrect. In deciding how to rule on admitting this juror or in paneling them, the judge can take it into account the fact that the juror said they could fairly consider the evidence, but that statement is not determinative. Hey, I could do it. I don't know. By itself, that's not enough for the judge to refuse to strike the juror for cause. So if you answered A, Again, I think you went too far. You overthought it. And I think you got the wrong result because this just feels like they should be able to dismiss for cause. So I think that A and B are both going to be wrong. And what do you know? That I'm right about that. Answer B said no, because the wholesaler's attorney could use a peremptory challenge to strike the juror. Peremptory challenges certainly would allow you to do that based on an attitude or characteristic that's unfavorable to your client, but doesn't rise to the level of bias or a relationship to one of the litigants. But here, this juror clearly has a relationship to one of the litigants, and I think it's pretty biased. And whether the wholesaler had peremptory challenges remaining is irrelevant. It's a distractor. So if the court finds that there's an objective standard for disqualification for cause, they have to excuse the potential juror. So hopefully none of you thought in your initial analysis that the answer of being able to strike the juror for cause was no. That should have been your gut reaction is, of course, they can strike him for cause because we've all seen a bunch of TV shows and we've been to law school. So A and B, hopefully nobody chose that. What about the two yes answers? Answer choice C said yes, because other potential jurors still remain available for the jury panel. Who cares? It's totally irrelevant. If you chose C, come on, you better than that, right? Because what we're really looking for is the juror's relationship to the litigant or evidence of bias. It does not matter how many available jurors there are in the panel. And that leaves us very clearly with answer choice D. And that's why it's such an easy question. It's the only decent answer that gets to the right result. D says yes, because the potential juror is presumed to be biased because of his relationship to the company. Stock ownership, having worked for or having a spouse that works for one of the litigants, that has been found to create a presumption of bias, and that's how we strike jurors for cause. So hopefully most of you got that and you understood what was going on there. And that was our third question. Fun stuff, huh?
Yeah, everybody did a really great job. So hopefully this makes sense. And I think now one thing I love about this is it's part of the spiral review or stepped repetition is that we talked, you've learned this in the lecture, you've learned this in the outline, you've done questions on it. Now we've talked about it. I really believe truly at my core that if you see a question that has to do with that 14-day after the last pleading deadline, you're going to know it in your gut. It's just going to be like a part of you. And you're going to get that right when you see it on the real exam.
Yeah, and if you had difficulty or if you want to go deeper, you'll have the mind map available and you can add to the mind map for yourself as you do more jury questions. And we took 3 here. There are many jury questions available. So you can build out that mind map, but we've given you the core of it. It'll be in your course. It'll be in your federal civil procedure, and it'll show as an optional assignment. Again, if you're not in our course, get in our course. You can also buy all of these deep dives that we do as a separate package, and we'll put that available for you. Thanks everybody for participating. Thank you, Megan, for getting us there. I didn't think we were going to get through all of that, obviously, but we did. Very cool. Any last words as we wrap up heading into the California results weekend?
Oh, best of luck to everybody in California. We are thinking of you and hope that you have a good result. For everyone, please, consistency over this next week, right? Just a little bit every day, be consistent, put in the work now. Your future self will be very grateful when you hit July that you're working really hard in May. So go ahead and get that work done today and don't put it off.
Yeah. Great. Thanks for being with us, Megan. Thanks to all of you who are here watching live. And we will see you all again next Wednesday. Have a good weekend. As Megan said, consistency is really what counts here. We'll see you in the community group, and we'll see you here again next week. Take care, everybody. Bye-bye.
Bye.
Thanks for listening and watching the Extra Mile podcast for bar exam takers at celebrationbarreview.com.